right. Well, you just heard that CBS News special report. An appeals court in Washington, D.C. has ruled that Donald Trump does not have presidential immunity in his criminal case stemming from January 6th. So Katrina Kaufman is here in Studio 57 with us to break it all down. She's an attorney and a CBS News campaign reporter. And you have been basically on Trump court cases this sort of whole time. So this is what you've been waiting for. You've been sort of going through the decision. It's 50-odd pages. What's standing out to you?
I've only had kind of a moment to have a cursory look at this, but I mean, basically, they affirm that when Trump left office, he lost the protection of the presidency. He lost the protection of presidential immunity. So this claim that he made, it just no longer stands. And it felt very clear sitting in the courtroom when this appeal was going on in Washington, D.C., that the judges were very skeptical of this argument. You know, President Trump's claim that almost no matter what he did, he would be protected from prosecution. And so, yes,
a quick quote that reinforces what you're saying right there. And the quote is, you know, for the purpose of this criminal case, former President Trump has been citizen Trump with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president, it no longer protects him against this prosecution.
Absolutely. And the other thing that stands out to me is they basically say that it would destroy the separation of powers in the United States. You know, we have a system of checks and balances. The president is not supposed to be superior to all things. The court has to be a check on him as well.
So let's look at page 20, Katrina, because I think that's interesting of this ruling. And this is what the president's lawyers argued. And they argued, as you just stated, that there's a separation of powers, which means that neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts which are vested in the presidency alone. But the court, which says that the president and his lawyers relied on Marbury versus Madison, says that they got it wrong or they misread this case. Properly understood, the court writes, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every, and they emphasize every, official act. What does that mean to you?
That they won't immunize the president for every official act. I mean, I think even if you look back to President Nixon, for example, he was pardoned because he could have potentially been found liable for the crimes of Watergate. So I think that this is an example of that. Even if something takes place while you're in office, there is the potential that when you leave office that you could be prosecuted for those crimes.
So, right, because that's sort of the way I read it, and I'm not a lawyer, but we talked about the fact that he is now citizen Trump, and that's how the court sees him. But this is also suggesting that even when he commits an illegal act or an act that can be prosecuted as president, you're not covered under Marbury versus Madison, which is what the president's lawyers argued.
Yeah, and I think that was evident during the questioning of the immunity appeal as well. I remember Justice Florence Pan, you know, she asked that question that I think has now been quoted many times, you know, can you ask SEAL Team 6 to kill a political rival while you're in office? And then there's no consequence for that. So I think this is just to show, yes, he is now a citizen, but even as president, I mean, you don't have full reign to do whatever you want.
So then what does this mean for this case? This is the insurrection case, the January 6th insurrection case, that there are many, many other people who have gone to court and been sentenced for their participation in what happened on January 6th. It was on the calendar for March 4th, I believe, and then mysteriously disappeared. What now?
Sure. I mean, I think it was inevitable that March 4th just wasn't going to work at this point because basically for every day this trial has been delayed, there is pretrial activity that needs to resume. I think now I'd have to look at the timeline, but spring seems like a realistic option. I know that Judge Chutkan has some things on the docket for early April, and also this order does say that Trump has until February 12th to appeal to the Supreme Court.
Right.
So that is a step where we'll have to see what happens with that. But, you know, I do think now it is more and more likely that this case is going to move forward, and it could move forward in the very near future.
And he would have to stand trial for his connection to an alleged insurrection.
So I want to talk to a congressional correspondent, Scott MacFarlane, about that very point. He's been following this case. He's outside the courthouse. in Washington now. Scott, you probably heard Anne-Marie and Katrina talking about possible dates for this case, which would be well before the presidential election. What do you make of that?
Timing was everything for this appeals court ruling. There were some impatient folks waiting the month it took between oral arguments and this ruling. But what the appeals court has done has really set the table for this trial getting back on the calendar as early as this spring. The initial trial date you mentioned was March 4th. CBS News was first to report that that trial date disappeared off the court calendar last week as the judge in the case waited for this appeals court ruling to come back. As of next week, this case could go back to the authority of the district court judge, Judge Tanya Chutkin, who has spoken in court about the need to get this thing done promptly because, in her words, Donald Trump is just any other criminal defendant and does not deserve special privileges. But there's a logistical issue here. How do you get a trial date for a potentially 6-week trial with all the unique security protocols that are going to be needed back on the calendar of a courthouse that is a very, very full courthouse? There are 1,200 plus January 6 cases, much less the other cases in D.C. that are going through the court. Now, the judge will have next week the ability to put it back on the calendar. There is certainly some time available for the election, but it's narrow. And if the appeals court had waited weeks longer or months longer before returning this ruling, it may have been impossible to get back on the calendar before the election. Now it's very much possible, if not overwhelmingly likely.
The president has had kind of loss after loss. He lost the E. Jean Carroll case, and he's lost this case. We learned earlier this week that, $50 million of donated money has been spent on his defenses. And as you point out, Scott, this case is we haven't even started really with this case. Yet, I expect an email is going to be going out.
Fundraiser.
If it hasn't already, appealing to donors for more support. Can we expect, though this seems like a really clear loss, but can we expect the former president to be using this as part of his campaign, as he has with every other case?
If past his prologue, absolutely. Not only is it a fundraising tool, it's proven to be a very effective fundraising tool. But here's the bottom line. I don't think people have a proper appreciation for the size and scope of what this trial would be, the spectacle it would be. Unlike those cases in New York, those civil cases, he can't come and go as he pleases. He's a criminal defendant. He would have to be here in the court every day for weeks at a time. That in itself is a spectacle. What's more, this case with tethers to January 6th and efforts to overturn the election is the case with which Americans are most familiar. This is not an obscure classified records case, or it doesn't involve hush money or civil law. This involves January 6th and the efforts to subvert an election, things people watched on live television. It has the potential for jaw-dropping, visceral moments. And it's going to play out over the course of weeks, not days. It's going to shutter much of the nation's capital for security reasons. It's going to be a true spectacle. And this appeals court ruling sets the table for it, actually happening before the election, which was in question during these appeals.
So let me ask you then, Scott, for those members of Congress that you've been speaking to, who have already thrown their support to President Trump, in some cases have endorsed him, will this give them pause? Because there are a number of people who have wondered, why is Nikki Haley still in this race, given that the RNC, the former president, his supporters, his sycophants have all said that he's all but locked up the nomination. If you are somebody who has thrown the endorsement to President Trump, will this give you pause? And if you're somebody who has not yet endorsed either Haley or Trump, if you're Nikki Haley, do you see this, as terrible as it is for this country to be going through a situation that the one you just described, as a small light at the end of the tunnel?
We haven't really seen the filing of the criminal charges or the pre-trial motions in this criminal case or the others dent Donald Trump's political support, and there's really a shrinking number of members of Congress who've yet to endorse him. And those who've endorsed him include the leaders, all of them, in the U.S. House, much of the senior Senate Republicans in the Senate Republican caucus. But at a minimum, a trial and how it plays out. A verdict in a trial, if it happens before Election Day, has the potential of being a game-changing moment, but there's been no indications yet to guarantee that's true.
All right, Scott MacFarlane for us outside that D.C. courthouse. If you're just joining us, former President Trump has been denied in his immunity appeal in the January 6 case. Scott, thank you very much. Let's bring in Tom Dupree for analysis. He was a principal deputy assistant attorney general under the George W. Bush administration. Sir, thanks so much for joining us. Again, we have been dissecting this 57-page ruling and what people are going to want to know. Those folks who are at home watching this and are watching this on their phones in the middle of their workday when they just want to understand what this ruling means. How is the court viewing former President Trump's claim that he has immunity for anything that he does, that he did while he was in office or even out of office?
Well, they rejected that claim across the board. They basically said that former President Trump, for present purposes, is citizen Donald Trump, and he enjoys no greater protection against criminal prosecution than any other citizen of the United States. The opinion is somewhat of a tour de force. It's a long opinion. It's nearly 60 pages. The three judges reached unanimity, so there are no dissents. And the court did a fairly deep dive into both history, into constitutional text and structure, into the policy arguments that underlie both sides' cases. But at the end of the day, their ultimate bottom line was very clear. Former President Trump is not immune from criminal prosecution for activities he took when he was president.
And then, so moving forward, where does the actual case go from here? This is the case about his involvement in the January 6th insurrection.
Right. From here, the next likely stop would be the United States Supreme Court. The ball is in former President Trump's court at the moment. He has the right, and I suspect he will exercise the right, to appeal this decision to the United States Supreme Court. He's on a fairly quick timeline. The D.C. Circuit, the appellate court today, said that they need him to make his decision in about a week or so, whether he's going to try to get this case into the Supreme Court. Keep in mind, the United States Supreme Court doesn't have to accept this case for review. In fact, they declined to take most cases that are presented with them. So it's not a sure bet that the United States Supreme Court is going to want to grant review and is going to want to hear this case. But that's really the last stop in the train for former President Trump, at least at this point in time.
And then based on, and I know, everyone's just getting this 57-page document, but on what grounds would they be able to appeal to the Supreme Court? You can't just say, I don't like the results of this. I want someone else to look at it. There has to be a reason, right? Do you see anything in there?
Sure. I think what the former President Trump's lawyers would argue are a few things. One is that they would argue that the Court of Appeals simply misread the Constitution, that in their view, at least, presidents need to be granted this sort of immunity in order to do their job. I'm not saying that's a winning argument, but at least that's the argument they are likely to make, that the Court of Appeals basically bollocksed up the Constitution and got it wrong. The other thing I think they'll say is just the importance and the gravity of this case. That's something that the Supreme Court thinks about when deciding whether it wants to take a case, is how important is this case to the legal structure and to the country as a whole? And on that front, obviously, they can say this is about as important as a case gets, and it's definitely something in their view that would be worthy of Supreme Court review.
One of the things that I would love your take on, which is what a Republican who served in multiple administrations said about where the former president wanted folks to understand what he was trying to get at. And her name is Karen Henderson. She wrote this: I think it's paradoxical to say that his constitutional duty, meaning the former president, to take care that the laws be faithfully executed allows him to violate criminal laws. Can you, again, it's pretty plain here, but I want people who are tuning in to understand why somebody who perhaps is a supporter of the GOP would suggest that what the former president is asking is absurd.
Right. Well, I think what that point gets at, and Judge Henderson is someone who comes from a Republican background and may well be politically supportive of the former president. And what she's basically saying is that under our Constitution, the president does have a requirement, a duty, to take care that the laws of the United States be faithfully executed. And that was the basis for former President Trump's argument as to why he should be immune, that if he didn't have immunity, he couldn't execute that duty. And so what she did was she basically turned around that constitutional text on him and said, look, the right or the duty to take care that our laws are faithfully executed doesn't give you a license to defy and disregard those laws in your own personal conduct. So I think it was her way of saying, look, yes, you're quoting the Constitution correctly, but it doesn't quite mean what you think it means.
So, according to what I've read, and again, I've always prefaced it that Anne-Marie and I are not lawyers, but the impeachment claim that the former president made, he seemed to rely on this one line in the Constitution saying that while Congress can only remove a person from office, and this is the line, the party convicted shall nevertheless be liable and subject to indictment. So he had argued that that must mean the opposite is also true, that a president who is not convicted may not be subject to criminal prosecution. What did Judge Chutkan say to that argument, if you recall?
Oh, I recall very well. She didn't buy that argument. And look, that's what the former president's lawyers had been arguing. They had basically said that unless you're actually impeached and then convicted by the Senate, you can't stand trial on these criminal charges because in their view, at least, you've effectively been acquitted through the constitutionally prescribed procedure. She said not so fast. She said the actual clause of the Constitution simply says that, yes, you can be subject to impeachment proceedings, but whenever that is done, and if you're out of office, that doesn't preclude the possibility of a subsequent criminal proceeding against you. So there you had a disagreement as to what the constitutional text meant, and the district court basically rebuffed and rejected the former president's arguments.
I want to ask you a little bit about sort of the full philosophy behind the argument, right? Which is basically, and this is going to be me and regular people speak, right? Which is basically, when you're the president, you got to make tough decisions at times. And some of those decisions may harm people. They may appear criminal. If you weren't a president, they perhaps would be. You wouldn't be given leeway. But you have to have some sort of protection. And I think he brought up police officers and maybe even priests or something along those. He brought up.
Oh, yeah, he brought up priests.
Yeah, sorry. So that was part of the argument that it's tough to be the president, and if you're always considering that you may be sued or you may be charged later on, you won't be able to make those tough decisions.
Yeah, well, look, for a non-lawyer, you articulated that argument very well. That's exactly what they were arguing. They were basically saying that, look, if you subject the president to possible criminal liability, they're going to be looking over their shoulder every day. They're not going to be able to execute the duties of their office. If, for example, they ordered a military strike on someone, God forbid, years later, someone could say, well, that actually violated the law and you need to be prosecuted for that. So that was what they were saying. You can't have a president doing his or her job if they are saddled with the possibility of criminal liability. Now, the counter argument to that, and I think what a lot of Judge Chutkan and the D.C. Circuit in today's opinion were grappling with, is to say, look, we don't want to hobble presidents and their ability to do their job, but at the same time, it's not asking too much to say that the president, like any other American, needs to follow the law. And yes, you have to have protection so that presidents aren't sued with, hundreds of frivolous lawsuits the moment they leave office. But at the same time, no one is above the law in the United States, and it's not asking too much of our presidents to demand that they conform their conduct to the requirements of the law.
So, Tom, there was something else that sort of was interesting as a student of history that I noted, which is that Judge Michelle Childs noted during the oral argument phase that after resigning the presidency, Richard Nixon received a pardon, right? We famously, Gerald Ford pardoned President Nixon for any criminal activity. And the line was, this is the quote, any criminal activity, quote, he may or may have committed or may have committed. So wouldn't that mean that that precedent is set that there's an acceptance there that you could have been charged with a crime had President Ford not given you this pardon? Am I wrong in thinking that way?
No, that's I think exactly the argument that the opponents of President Trump were making, is they basically were saying, well, if you're right about this, then President Nixon didn't need a pardon after all. It was all for nothing, that he was immune anyway. So that can't be right. And look, I think that's one of the fascinating aspects of this case, is that you can draw upon history. You can look to historic precedents from our nation's history and our traditions as to what the scope of this immunity, if it exists, really is. And I think a lot of folks like you did have looked back to an arguably analogous situation after former President Nixon left office and got a pardon and said, well, if presidents were truly immune, there was no need for President Ford to have done this. So again, it's a good historic argument, and I think one that the D.C. Circuit, at least in part, embraced today.
So the D.C. Circuit ruling, as you know, Tom, is not binding in any other jurisdiction where President Trump is accused of a crime. He's making similar arguments in Georgia, where he's accused of interfering in that state's 2020 election. But in that case, the former president is arguing around the supremacy clause, which bars state prosecutors from indicting a former president. Even though this ruling is not binding in other states, can the judges in Georgia look to this ruling for guidance?
Yes, great question. And the short answer is yes, they can look to it for guidance, and I am confident they will look to it for guidance. The way that lawyers would describe this is, you're right, it's not binding on other courts outside of Washington, D.C., but it's what lawyers and courts and judges would refer to as persuasive authority. In other words, it's another court, I should note, a highly respected court, the D.C. Circuit Court of Appeals, that reached this decision on presidential immunity. And does the court in Georgia absolutely have to follow and accept that decision? Technically, no. But I think that they will read it, they'll see that it's a seriously reasoned decision, and they'll probably give it great weight, if not controlling weight.
So say this trial gets postponed and Trump wins in November. Is he protected? Could he, preemptively pardon himself?
Well, if Trump wins in November and this case, the January 6th case in D.C., is still going, I think at that point, the legal world changes. The moment that President Trump, if he's reelected, is inaugurated, he has the power and the authority to direct the Justice Department to immediately drop the prosecution. I don't think there's much debate that he has the power to do that. As the chief executive, he oversees and controls the Justice Department. He controls their prosecution decisions, and there's nothing that would stop him from directing the Attorney General to immediately drop that prosecution. If we're in a world where he had been convicted before the election, but then after the election he comes into office, I think it's an open question whether or not a president could actually pardon himself. And I suspect if he tried to do that, I think that is a case that likely would work its way up to the United States Supreme Court for decision.
Right, but
it's not something that's ever been decided in our nation's history.
Yeah, but Tom, he wouldn't need... we're having this conversation.
I know, but Tom, he wouldn't need to pardon himself, right, if he's elected president. He could just say...
But if he was already convicted.
Yeah, but he would still be president of the United States.
Yeah, but if he's convicted, he's going to face a sentencing of some sort. So he would have to pardon himself so he wouldn't have to face that.
That's interesting.
Exactly. This is crazy.
Yeah. We're in uncharted constitutional territory here.
Yes, indeed. Tom Dupree, this has been really insightful and very clear. Certainly for our viewers who are just tuning in, who are following along with the story, Tom, we so appreciate your insight. Thank you very much.